Good morning, everyone, to this day 2 of the Big Units Limited application hearing. Welcome to those new people in the room today, and also to those online. First of all, for those who are in the room, the emergency procedures are to exit through this door, turn hard left and out onto the grassed area beyond. It's reasonably important to know. Just to recap on where we're at in the process, yesterday we heard from the applicant's team, and we also heard from 3 submitters from the local area. And today we're going to hear from 2 more sets of submitters, and then we have the officer's report, and finally the applicant's verbal sum up to be followed by a written reply and potentially another site visit by the commissioners. So it's a reasonably full day, so we'll see how we go. But my initial impressions are we have 40 odd minutes for the first submitters and a bit longer for the second, but it's possible we might take a little bit longer with the first submitters. But overall, I'm pretty confident we'll get to the officers by about 11:45 or possibly even a bit earlier. So let's see how we go with that. And before we get started, I just going to ask Mr. White to report back to us on any advice he may have received in relation to the appeal, the outstanding appeal for PC19. It's relevant to this application. Mr. White, have you managed to get any information on that?
Thank you, sir. I had a brief discussion with Anne Rogers, who's involved in the appeal on behalf of the council last night.
Yeah.
And we're talking about principally the guest appeal, and it's yet to be resolved. This where things are at. I understand Mr. Gresham is representing parties in relation to that appeal. So he also has some, you may also want to question him on this aspect. So an agreement was put before the court, and what I understand is the court has some questions about some of the 274 parties and the relief sought and whether they have scope the relief that they're seeking. I tried to have a brief discussion about the matters or the observations in the panel that it would seem that the objective isn't subject to appeal. The relevant policies are, and they are still subject to change and could change. And then on that matter, the online district plan is an up-to-date version of the plan as it stands, although the planning maps aren't up to date. And so on that point, Precinct 1 council officers also reminded me when we're talking about Precinct 1 with the LRZ, that applies in a number of locations, not just Pence and Warrens. So it's unlikely to be resolved in a decision-making timeframe, field decision.
So the court hasn't considered the merits at all. It's purely going through the process of the 274 parties and the procedures and that sort of thing. So
there's some I understand there are some questions about, can those 274 parties get the relief they're seeking in eligibility through the submission process, but maybe that is something you want to actually Mr. Gresham further. But then in a nutshell is as much as I can really say.
That's fine. No, that's useful because we had no idea where it was at, so now we have some ideas. Yeah, thank you very much. All right. It's useful, and yeah, just a question you might like to add to that if you wish when you present. So right, we'll thank you for that. We'll now go over to you, Mr. Gresham. And we've got your legal submissions.
Yes.
We've read the evidence that you're about to call as well. So.
Yes. Thank you, Commissioner. There's one point of clarification I wanted to make in terms of paragraph 2 of my submissions.
Yes.
The loopers are 13A, the unit 12, but the address is 13A, period place. The 23B is Mr. Morsick's property. Submission was jointly lodged on behalf of, but in terms of today, we're just representing Mr. and Mrs. Worker.
Thank you. And then do you have the client with you today? Or?
Yes, this is him. Yeah, apologies. This is him when I left, and Ms. McCullough was on my.
Yeah. Thank you. All right. Well, yeah, so we've got your legal submissions, and you're welcome to address us on those. We've made some questions, but
Well, I wasn't going to read through them, other than to, and Ms. Mackay is going to speak, or read a summary in terms of her planning evidence. But the main issue I was going to speak to is how we essentially both weigh and apply these plan change 19 provisions. And I can pick up on that discussion in terms of that appeal. So essentially, as I think you know, that there's some general relief sought by De Geest in terms of the provisions of the large lot residential zone. Those are supplementary in a lot of ways to its primary relief, which is the rezoning of specific land that it owns. The outcome that's currently before the court by way of consent memoranda relates to essentially some changes to the objectives and policies of the large lot residential zone. There aren't changes sought to the rule relating to residential density. So essentially what the situation we're in is the court is being asked to endorse those provisions, which if they are endorsed would confirm the density rule as it currently stands. And I think the issue which Mr. White was alluding to in relation to the Section 274 party, that was a specific query the court had. Not relevant, I think, to this consent. It was to do with whether a 274 party could essentially pick up some of the not agreed provisions and essentially take the appellant's place in respect of those, so that they were quite discrete points in terms of the policies and matters of discretion, but not really to do with this consent. So,
primary relief was to rezone the property. So can I take it from that if the property was rezoned, that would not resolve the appeal? There's still some matters to do with the policies and objectives. Is that right?
that's right. Although if what's being put to the court by the parties, it would, other than the two discrete matters that are not resolved, that would resolve the appeal for all intents and purposes, including the relief outside of the rezoning aspect, if that makes sense.
I think, I think I understand that. It would be useful to have that explained in writing if that's possible, because I think it is relevant. And I guess we have, it's been put to us by other counsel that it's a site-specific appeal, and it clearly is. But the issue is the wider ramifications of the appeal being successful on the other provisions, and that would then be relevant to this. So I think the panel would like to have some certainty as to what the scope of the appeal is. At least, we know that it's not resolved, but it's useful to know that.
Well, I can certainly do that, and I can set out where it's got to. I was a little bit nervous. I do have a copy of the consent documents that were filed with the court.
Oh, yes.
Which I think it's, given they've been filed, it's okay to provide, which would explain. Obviously, they're not endorsed, so they don't represent any change in the provision.
If you did send those in with your initial submissions, didn't you? And withdrew them, but I guess they might be of use to us to go back and look at those in terms of the factual statement of what's been filed.
That's correct, and specifically the main point in terms of those is the relevant rule, density rule, is proposed to be unchanged if this package of relief that the parties have sought is endorsed by the board.
The density rule will be unchanged, the 1 per 1,000.
That's right.
Is that essentially an operative rule then? Is that the case?
Once once the appeal on that rule gets resolved one way or the other,
Right.
then it will become operative.
I see. Yeah, depends on that.
Yeah.
Thank you very much.
So on the issue of PC19, I understand there was some discussion yesterday about how, I don't think the issue is so much, do we give weight to these provisions? I think it's fairly in consensus that you should give relatively strong weight to them. But the issue is perhaps more how you in fact apply them, particularly given we've got this issue where consent was sought under the operative plan, and there's no dispute that the activity status of PC19 doesn't apply to this application. But you are still in a position where under section 104, you need to have regard to the provisions of PC19. And that includes obviously the objectives and policies, but it also includes the rules. And when you've got this density rule that is yet to be operative, but is clearly something that the council have signalled should apply to this site, then you have to have regard to that under section 104, and it informs your assessment of whether this development is what the plan envisages.
And so if I've got that right, the objective 2 is not subject to appeal, and objective 2 talks about low density living environment, and the rule what I'm taking is, even though it's not operative and it's part of the appeal, that can't be changed either, because that's what you told me, the rule and the objective 2 and the rule that supports it can't be changed. The policies can, they're still subject to appeal, but there's the sort of bookends, it's the objective and the rule essentially beyond change. Is that right?
Yes, well, legally it's not beyond change in the sense that that rule was part of the appeal. But as I say, if that what's being now sought by the parties through that appeal is granted, then that rule will be confirmed as it is.
Yeah,
so it is still.
So if the appeal is rejected or not accepted by the court, then that rule could potentially disappear. Is that right?
No, if the appeal was rejected by the court, the rule would stay as it is.
The rule would stay as it is.
If the appeal was to pursue changes to the rule, then it would still be subject to challenge. But if the court was to, or if, as the parties have signalled they intend to, essentially not challenge or no longer challenge that rule, then the rule would stay as it is.
Yeah, sorry, I understand. Thank you.
And in terms of, the objectives and policies themselves, and this relates to the discussion I think you had yesterday in terms of whether the matters of discretion, whether the matters in PC19 objectives and policies fall within the matters of discretion you can consider. And I think it's agreed that they do, and that the objectives and policies themselves aren't as prescriptive as the rules in terms of density outcomes for this zone. They speak about obviously providing for amenity values and those sorts of things, but what you can then glean from the rules and the density provisions that applies, what kind of amenity values are being sought to be protected, and what is, for an example, a pleasant low density living environment within this site. And you can get an understanding of that from the fact that the plan seeks to provide for 1,000 metre, one residential unit per 1,000 metres. So that's the way in which you have regard to those provisions under section 104.
Right. Thank you. That's I understand that now very much. All right. That's probably a key part of your submissions, but please take us through the rest.
Yes. Well, the only other point, and really it's I was just going to clarify in terms of a couple of matters which Mr. Gardner Hopkins raised in his submissions, which I don't think are an issue one of which is scope. I don't think it can be said that the changes to the proposal go outside the scope of the original application. And it's either a refinement of effects or what we say really is no substantial change to the effects of the proposal.
And I take it from that, you would accept that the activity status, whether it be RDA or full discretionary, doesn't affect the scope of the application as lodged, because that was a line of reasoning you put in the submissions, that it could be full discretionary potentially.
Yes, so the full discretion, that goes to the point around the site coverage requirements.
Yeah.
And again, aware from yesterday's discussion in terms of the subtleties of that definition and whether it doesn't in fact apply to these sites because they're not rear sites. And there is a valid point there because it does raise the question as to why you would provide for rear sites, but any allotments. So it does seem that the two, both allotments and sites, they have to be rear to be.
Yes, I was going to ask your planner, and I probably will ask Ms. Mackay. Yes, I was going to ask you what the planning rationale for that was, and that might help understand the definition and what it's meant to achieve. So, but if you do accept that, then you're accepting there's no issue of scope.
Yes.
That we can move on from that. So,
yes, and we're accepting that you'd be entitled to accept the applicant's position that this is a restricted discretionary activity, and ultimately it would probably be more of a issue if there was some effect or matter which was outside those matters of restricted discretion that would otherwise be considered in this proposal, but there don't appear to be. The matters are, it's an interpretation exercise in terms of when you're looking at matters of discretion like amenity values and those sorts of things as to what it means. But in terms of whether the relevant considerations fall within those matters of discretion, I don't think it could be said that they do. I think any issue that's on the table in terms of this application does fall within the matters of discretion.
And they appear to be quite wide matters of discretion for a restricted, they're fairly wide ranging, aren't they?
Yes, exactly.
Yeah, okay. All right, thank you for that. Probably answered many of my questions. But let's go through the point Mr. Gardner Hopkins made was that the discussion around density and 6 units versus 2, you've called planning evidence on that, but the only urban design evidence we have from Mr. Weir and Ms. Eaton is that, as we understand it, 6 units is basically acceptable on the site, subject to amendments, modifications, streetscape issues, and the like. So, in terms of what's appropriate from the talk about this transition from the lower density to the higher density resort, the evidence we have from an urban design specialist perspective is that it's acceptable to have development of this kind on the site, subject to modifications. Do you have any response to that, or should we still apply the planning criteria from the planner as being of equal weight?
Well, I would, in terms of that latter point, I would say planning criteria are important. We're not in a position and don't challenge the urban design evidence per se and the effects, the merits issue from an urban design perspective in terms of this proposal. But what we would say is that it is important when considering that evidence to make sure that it is considered in the proper planning context. At one point, I do make, Ms. Mackay's may have alluded to it as well, is that it appears that the council's urban design assessment was in the context of the operative plan, as opposed to what the plan envisages from an urban design perspective in terms of Plan Change 19. So there is that planning lens that is very much at play in this case. It's not simply a merits assessment in terms of an urban design opinion.
That's good, that's fine. And we will ask Mr. White for your team to address that, because it does seem to be an omission, and it might be that Ms. Eaton can bring some of the assessment under the operative plan through and relate it to PC19 in case there are similarities in some way. But yeah, we will need to have something from her that deals with that. Thank you. I'll just see that. Yeah. Another, probably the last question I have is we're trying to grapple with this concept of the LLRZ low density zone, including the resort, which is clearly not a low density development. And are you aware, Mr. Preston, of anything in Pay Change 19 that refers to the resort in any way to show that it's been considered as being, it should be included, it's appropriate to be included in the zone? We've looked at the provisions for the LLRZ, and I'm not sure it makes any reference to the resort, but I know it has its own history. It was consented through some time ago, and it is there. But the question is, we've got a new PC19 that endorses that development as being appropriate in a low density zone. So, do you know any more about that?
I'm not aware of, no, I can't recall any discussion, certainly not in the provisions themselves or in the user documentation or anything like that, or the hearing, the commissioner's decision. Yeah, I couldn't speak to that.
No, that's fine. We can only deal with what's in front of us, but it was a curious thing to understand, because it's quite different from the balance of the zone, and we're considering here what's called a transitional area, and it's debated both ways, but that's a key thing we'll test with the evidence. Anyway, look, that's all the questions I have on legal matters, but thank you very much.
Thank you.
Okay. All right.
Thanks. It's Mackay.
Thank you. So I've prepared a short summary statement which seeks to address some of the matters in my primary evidence, supplementary evidence, and to address some of the matters that were raised yesterday. So I'll just talk through those. I will also forward on a copy following the hearing. Sorry.
Oh, okay, that's fine.
I'll send that through.
Yes.
So the evidence, as I've said, will address some of the recurring themes that were raised during the proceedings at yesterday's hearing, including weighting against the operative district plan and plan change 19 provisions, the site area calculations, activity status, the transitional nature of the site, and the consenting history. In terms of the objectives and policies, Mr. Gresson has already touched on the weighting elements there, which I agree with. So the site has been rezoned under Plan Change 19 from residential resource area 3 to large lot residential zone from precinct 1. My primary evidence provides an assessment against the ODP and PC19 objectives and policies, and finds that the proposal is contrary to the objectives and policies of both plans. With regard specifically to Plan Change 19, while I agree with the applicant and the council of planners that the proposal is generally consistent with LLRZ01, objective LLRZ01 and policy LLRZP2, overall I consider that the proposal is contrary to the remaining objectives and policies for the following reasons. The site is zoned LLRZ, and the densities within this zone are the lowest of all the residential zones. Excuse me. Of note, the density standards for precinct 1 is anticipated to be 1 residential unit per 1,000 square metres. As a contrast, the low density residential zone under Plan Change 19 anticipates density of 1 residential unit per 400 square metres. The development proposed by this application does not come close to the large lot residential zone density standards, and even falls short of meeting the low density residential zone standards. The proposed multi-unit development is therefore not appropriate in this location and will not maintain the amenity and character resulting from existing or anticipated development in this area. It is my opinion that the Plan Change 19 objectives and policies should be given more weight than the operative district plan objectives and policies, given how far PC19 has progressed. The outstanding appeals relates to policies LLRZP6 and the density standard for precinct 1 being LLRZS1, although that has been discussed in further detail by the lesson this morning. It's my understanding that these matters are still subject to appeal and are bespoke to site-specific bespoke to a specific site and will not have any substantial implications or changes to the site located at 9 and 11 Perriam Place or to the wider large lot residential zone. For these reasons, I consider that there's a suitable degree of certainty as the Plan Change 19 provisions apply to the subject site and in particular the zoning and density standards anticipated. In terms of the site area calculations, I note that there has been a difference in how the definition relating to access lot or access strip is interpreted. In my supplementary evidence, I consider that this applies to any allotment and the proposed access strip should therefore be excluded from the site coverage calculations, thus rendering the overall activity status of the proposal as discretionary. However, the commissioners and the applicant team consider that this should be interpreted as a real site or rear allotment in the subtleties within the definition. It's also clear. If it was intended to relate to all allotments, the word rear would likely have been omitted from the definition. So I can see this from both sides and suggest that the Commission requests clarification from Mr. White in relation to how Council have previously applied this definition. As above, if the access strip is to be excluded from the overall net site area calculations, the overall activity status of the proposal would become discretionary under the operative district plan. While the activity status would change, the nature and scale of the proposal would remain the same, such that I do not consider this would substantially alter the proposal. As a discretionary activity, the assessment could consider anything, as the matters of discretion would not be restricted to those matters previously considered. I do, however, recognise that the existing matters of discretion that the proposal has been assessed against are already broad enough to capture any changes in activity status, and I do not consider that the assessment as a whole would change substantially. While it would be good to confirm the correct interpretation, this may be a moot point given that the nature and scale of the proposal and associated assessment matters would not be materially impacted. There was some discussion yesterday and again this morning around this transitional nature of the site, with the applicant team assessing that the site is a logical transition from the higher density built form of the Marsden Lake Resort to the lower density standalone residential units on RRA3. In my opinion, the transitional nature of the site would actually apply in reverse. I consider that the subject site represents a predominant corner site, which could be more appropriately and more sympathetically developed at a lower density that reflects and integrates with the established low-density residential character of Perriam Place and Foster Place before transitioning to the Marsden Lake Resort unit. I therefore hold the opinion that the proposal to establish 6 residential units on the site will be contrary to the intent of RRA3, which seeks to complement the character and amenity values of the streetscape and surrounding area. Following on from this, I consider that the proposal seeks to introduce high-density residential activities that will be inconsistent with the existing and anticipated character of the surrounding area and will not complement the character and amenity of the large lot residential zone. The proposal represents a significant departure from the existing and anticipated low-density character of the surrounding area. I also note that there has been little discussion around future permitted activities that could occur on the site in accordance with the Plan Change 19 provisions. Unlike in the ODP, PC 19 permits minor residential units, provided that there's a maximum of 1 minor residential unit per principal unit. The area does not exceed 70 square metres, and the minor residential unit shares the same servicing provisions. In this instance, should the Commission be of mind to grant consent for 6 residential units on the site, this could provide a possible pathway for each residential unit to have its own minor residential unit. For example, internal alterations to the built form would be permitted, such that the internal layout of the residential units could be reconfigured to accommodate a minor residential unit in each building. This could result in 6 principal units and 6 minor units, resulting in a total of 12 residential activities on the site, with additional adverse effects as a result of the increased density, including traffic generation, noise effects, and so on. I consider that this would result in more than minor adverse effects and would be entirely inappropriate for the site and LLRZ, which seeks to provide a low density living environment.
I'll just pause for a moment, Ms. Mackay. First of all, we should really have a summary statement on this because we've got evidence in chief, we've got the supplementary evidence, and now there's another statement you're reading out which we haven't got in front of us. And the point you just made hasn't been made in your evidence in chief or in your supplementary statement. So it's a new matter of evidence. It's not a summary. And I have some questions on what you just said as well. But yeah, so what I'd encourage you to do is when you're finished presenting this is to email it straight away to us.
Yeah, absolutely.
Yeah, and then we'll ask some questions. But as a general rule, I don't think you should introduce additional matters like minor units being added as part of a summary statement. That's all. Yeah, okay. But we will ask you some questions.
Yeah, apologies, I take that on.
Okay, and also in fairness to the applicant, that this will be news to them as well, so it's new evidence. Yeah. Anyway,
Yeah,
we'll carry on for the moment, but just wish to caution you on that.
In terms of the consenting history, an assessment of the consent history has been provided in the section 42A supplementary report. This addresses the previous consents applicable to the site, which were either declined or have lapsed. Notwithstanding this, at yesterday's hearing, Mr. Dunn suggested that the 2019 consent, which related to multi-unit development and a two-lot subdivision at 9 Perriam Place, was declined on the subdivision component, and that the panel agreed the consent would have been granted had the application only been for land use consent for multi-unit development. This is not accurate, as the 2019 decision states the following. Just read a little bit. The panel conclude that the proposed multi-unit development and subdivision is contrary to the intent of the RRA3 and will result in more than minor adverse effects on the existing streetscape and amenity values of the neighbourhood. For completeness, the panel notes that at the hearing, the applicant contended that if the application were resubmitted as an application for land use consent only, it would be considered as a restricted discretionary activity, and the council would be hard pressed to turn it down. For the avoidance of doubt, the panel confirms that the conclusions it has reached in regards to streetscape and neighbourhood amenity effects are directly applicable to the second restricted discretionary matter listed under Rule 7.3.3. I therefore consider that the 2019 decision recognises that the land use component to establish 2 residential units on the site was inappropriate, would be contrary to the intent of the RRA3, and would result in more than minor adverse effects on the existing streetscape and amenity values of the neighbourhood. Overall, based on the findings of my primary evidence, supplementary evidence, and this summary statement, I remain of the opinion that the proposal will have adverse effects on the environment that are at an unacceptable level, including adverse effects in relation to residential amenity on neighbouring and surrounding residential properties as a result of the location, nature and scale of the proposed built form, adverse effects in relation to shading, access to sunlight and privacy on the neighbouring and surrounding residential properties as a result of the 15-metre yard encroachment, height and recession plane breaches, adverse effects in relation to amenity values of the neighbourhood and character of the streetscape as a result of the design and layout, and the significant departure from the density of development that is anticipated in this area, and adverse effects in relation to infrastructure as it relates to the potential insufficient capacity to provide for the development proposed, particularly in relation to wastewater disposal and stormwater discharge. I also consider that the proposal will be contrary to the objectives and policies of both the Operative District Plan and Plan Change 19. The proposal seeks to introduce high-density residential activities that will be inconsistent with the existing and anticipated character of the surrounding area and will not complement the character and amenity of the large lot residential zone as anticipated. Thank you. I'm happy to accept any questions. And again, my apologies for.
Yeah, that's just it's a matter of fairness to and correct me if I'm wrong, but point you made about the minor units wasn't made in the main evidence.
No, that's correct.
Is that correct? Yeah, okay. Just I'll ask a question on that now, even though it's arguably whether it's admissible, but I'll ask you a question on that. First of all, the application that's been lodged doesn't show minor units. And so if we do grant consent, the consent will apply to this development, not to minor units. Now, I'm not sure about the legalities of whether this then becomes something that you could add things to without another consent, but my initial thoughts would be it would require variation or change of conditions, because that's not covered in the consent that's in front of the application in front of us. But secondly, how would that affect the coverage calculation if we're at 38% and this coverage limit of 40 to add to the built form would surely trigger the coverage requirement, would it not?
Yes, so if it went over the 40%, it would trigger separate rules. But I guess any internal alterations, so the residential units could potentially change entirely.
Within the buildings. I think that's
But the built form with Vulcan location would remain the same, but potential internal changes.
if that was to occur, there could be an increase in intensity. Yeah, okay. The applicant might wish to respond to that in the reply, but yeah, again, that's something we haven't considered, but yeah, please send that through.
Yeah.
All right. I'll ask you a couple of other questions and then I'll ask my colleague to ask you anything else. The 15-metre yard requirement, in your statements, you've said that that's an unexpected, it would be an unexpected outcome of the zone to have a yard that's less than that. And is that the way you've portrayed it to me? That's how I read it.
I consider that there's an anticipation for a neighbouring development that there wouldn't be built form within setbacks, whether that's road boundary, side, rear, or lake setbacks. Of course, it's a restricted discretionary activity, so there is a pathway to reach that. It's not prohibited and not compliant.
Yeah.
But there is an anticipation.
There's an anticipation, but there's even more than a restricted discretionary activity is possibly at the lower end of the scale. It's not full discretionary. There's definitely a pathway, and in fact, it's not uncommon for applicants to seek a reduction. And I think we've had a 5-metre yard approved on the site. I'm not sure we'll have to ask Mr. White about that, but I'm just curious about your calling it an unexpected outcome. It's not a building line restriction, is it? I think that's the point Mr. Gardner-Hopkins makes. It's in his submission, it's lesser, not a better word. It's more able to be varied than, say, building line restriction, which clearly signals that's where buildings are not to go beyond. It's a trigger for assessment. Would you agree with that or not?
Yes, so it's not a building line restriction, it's a yard boundary setback, and can be applied, you can apply to reach that through the restricted discretionary activity stuff.
But I do take about the expectation, and 15 metre does appear to be quite a large yard. You know, it's not a normal sort of 4 metre or 5 metre yard, it's quite a significant yard.
Yes, and it applies throughout the area. So in this instance, the boundary is relatively close to the lake margin. But in other instances, even where there's up to sort of 50 or 60 metre separation between the lake margin and the property boundary, the 15 metres would still apply.
Right, okay. And I'll probably ask you one more question, then I'll hand over. But again, going to the transition area, I'm really interested in that. And I'm holding up a map here. You'll know the site well, but what's been put to us in urban design evidence basically is that the resort forms its own sort of enclave, and it's surrounded by a road, and there's a lot of paved and sealed areas and parking and rubbish bins and service type functions at the back. And then there's this site, which is within that roving sort of enclave, if you like. And it's also got a walkway on one side, so it's basically got sealed form all around it. And then the balance of the development is on the other side of both those streets, and it's quite different. And in your evidence, you're saying quite clearly that that the transition should be in reverse, I think you called it, which means that it should form the same character as on the other side of both of those roads, rather than the area inside of those roads. So And I think you said that because it's a corner site, it's especially important. Is that right? So,
Yeah, I consider it's quite a prominent site as you're driving down Perian Place into the area, towards the Marathon Lake Resort. It's quite a prominent corner, and would be a good transition in terms of having that lower density residential living areas to transition.
How would it be a transition if it's low density? Would be exactly the same as on the other side of the road, just had two dwellings, wouldn't it? So is that a transition, or is it just the same as the development on the other side? I'm not seeing a transition if you have one house on each. Where's the transition?
Yeah, so I think in terms of the transition, it's probably less of a transition from what I'm putting forward, and that those lower density, more sympathetically designed built form on that area would be more appropriate than the higher density that is proposed.
So potentially somewhere between 2 and 6, or would you maintain it should be 2?
Based on the plan change 19 provisions, which would allow for 2 principal residential units and 2 minor residential units, I would suggest that 4 residential activities would be considered appropriate in this area.
How come it's
4, so that would be based on the 2 primary principal residential units and 2 minor residential.
Thank you. Yes, so paragraph 83, this is obviously evidence in chief, page 15. Make a statement that I'll try to get it.
Sorry,
Paragraph 83. Yep.
yes, sorry.
So, so there basically you're making that point that the scale and character do not complement the character and amenity values of the surrounding neighbourhood, which is predominantly made up of single residential dwellings on sections 800 to 1,000 square metres. And we've already talked about the resort being different to that, obviously, but it's still in the same zone. And also the restricted discretionary activity standards in the operative plan allow consideration of 1 unit on 250 square metres. So you're confining your statement there to the existing character, acknowledging that the district plan anticipates, I think we could say, as a restricted discretionary activity, more intensive development, 1 unit per 250 would be an expected outcome if it's a restricted discretionary activity. Would you agree with that?
Under the operative district plan, the density standards would have, as a restricted discretionary activity, allow for down to 250 square metres.
Yes.
In this area, with it being a specially zoned residential resource area being RA3, there is the anticipation that it's that kind of lower density type residential living. However, the objectives and policies do restrict to servicing provisions. So it's not in terms of the sizes, in terms of the density that would come through. It's
reticulated in a lot. So.
Yeah, reticulated wastewater and stormwater, I believe is the policy direction for it. But
yeah, but I guess that as a restricted discretionary activity, would it be fair to say that the neighbours could expect the application to be granted theoretically for 1 unit on a 250 square metre site if those servicing considerations are dealt with? You know. I mean, is that an unreasonable statement to make if it's restricted discretionary? Is that an expected outcome?
There is the pathway, and as you say, the restricted discretionary activity. So the assessment would be dependent on those matters of discretion in terms of the appropriateness and streetscape and amenity values, etc.
Right. Understood. Thank you. Look, I've asked enough questions, so I'll hand over.
Thank you. Ms. Mackay, in your supplementary statement, you acknowledge that the evidence put forward by the applicant that the shading studies demonstrate minimal adverse effects on surrounding properties. And then you go on to conclude that there are adverse shading effects. And I think in your statement today, you've also concluded that there remains adverse shading effects. Can you talk me through your views on that and how you've reached, and where you stand on that matter and the evidence that you're relying on to arrive at that view?
Yeah, so for the shading effects, there's the shading studies have been provided, and thanks to the applicant for putting them forward. There's still some concerns in terms of the effects relating to the pedestrian walkway, which is a public area,
Yes.
and how that would impact during the winter months in terms of ice buildup and frost. So the shading effects on those areas.
So, in terms of shading on neighbouring buildings, you're less concerned with that now based on the shading.
The shading studies seem to show minimal.
Thank you. Thank you. And in terms of the concerns around servicing of the site, were you here yesterday to hear? Okay. So the evidence that we heard was that it's not uncommon for further approvals to be required from council departments as part of engineering acceptance processes. What's your experience in this district on that matter? Is that something you're familiar with, the approach that this council takes to service it?
Yeah, while conditions can be included to address servicing provisions, my opinion is where there's uncertainty, I believe that those provisions and the sufficient capacity for those services should be provided prior to consent being, a decision being made on the consent, because there's still uncertainty in relation to this. And while there's the different options in terms of connecting to the reticulated service, the low pressure, even the conditions that were put forward by the council engineer talk about the low pressure systems being to the minimal amount of residential units, but there's no clarification as to what would be acceptable in terms of that number. Would it be, is one acceptable? Is it two? Could all six be provided under that scheme? So there's still uncertainty as to how that relates.
And so at that later stage, what could there was still uncertainty at that later stage and they needed to get through those approvals. What is the possible outcome of that in terms of risk to the applicant?
I guess the risk to the applicant is if the alternative solutions aren't feasible, then the development could not be given effect to in its entirety.
Okay,
Unless there were alternative solutions as agreed through the engineering acceptance process with the applicant and council.
thank you.
Is there any, just as a follow-up question, is there any other concern about that aspect if one system is chosen? In other words, if it can't connect to the reticulation and another on-site solution is required, have you got any other concerns about what that might lead to in terms of discharges or effects on waters or anything like that? Are you concerned with that at all, or embrace that in this information?
Yeah, so I probably need to defer to the engineering team to address the suitability of those matters. I know that the council engineer had said that the low pressure system was more susceptible to failure, and whether that would have any adverse effects on the water quality.
Thanks for that. I don't think I've got any further questions, but if you can just forward that statement through.
Yeah, absolutely. I'll do that today.
Okay, thank you very much. All right, that's so further to do.
Thank you. I'll also send through that summary of that appeal.
Well, that would be useful. Yes, thank you. And we'll circulate that to the applicant as well. Thank you.
Thank you.
All right. Now I think we'll carry on. We'll carry on before we have a break. Right, have we got the Ms. Appleyard or Ms. Parker online?
Yes, we do.
That's good. Okay.
You've got both of us. Yes, I'll just introduce myself. My name is Jo Appleyard, and I have with me Ms. Tallulah Parker, who has prepared the legal submissions and helped prepare the evidence in relation to this case. Charlotte, are you there? I think our planner is there in person, so.
Very good. Okay, thanks, Ms. Appleyard. We've read your submissions as usual,
Yes.
and the evidence, and you're
Yes.
welcome to address us as you wish.
Yes.
Possibly reading them out, but there's certainly.
Yes, no, I wasn't going to do that. What I might just do is clarify. We act for a group that are broadly called the residents, and there is an appendix attached to the submissions which sets out who those parties are. Some of those parties have also filed individual submissions and or have wanted to speak to the hearings panel themselves, and I think a couple appeared yesterday. And I might just introduce you to Mr. Grenfell. He's actually online, so he is also a submitter as part of the residents group, and he has actually also filed a submission in his own right, and he has a few things that he wants to say himself. So I said we can hear from him at the end of the presentation.
Yeah, that's fine.
Yes. Now, having sat through this morning, I would just like to say I'm much obliged to Mr. Gresson, as he has introduced the consent memorandum documentation that brings things up to date with PC 19, and I listened to your exchange with him this morning, so he's probably taken things one step further than I had in terms of my submissions. So what I was going to propose to do was to thank him because he has gone through the issues we'd raised in our submissions in some detail with you this morning, and perhaps start with usefully using the time we have allotted with hearing from Charlotte, given that she's in the room, and then any few words from Mr. Grenfell. And then at the end, I can address any legal points that you haven't covered with Mr. Gresson, who I am in complete agreement with, if that's a sensible way of dealing with it.
Yeah, that's fine. I'm happy to do that. So we'll just give us a moment to get that evidence up, and then we'll.
Yes, and I think, Charlotte, you've got a summary, haven't you, that you can circulate that might assist the commissioners, if you could do that now.
That's the first test, Ms. Woodson. You've got a summary statement that's not longer than your primary statement.
Yeah.
I have seen.
Well, the first he says she has one. And then the second.
Okay, very good. Okay, so yeah, so maybe let's just read that to us. It'll be useful. Thank you.
Sounds good. Kia ora koutou. My name is Charlotte Clouston. Prepared primary evidence dated 24th of September and then supplementary evidence dated 11th of November. My opinions in my primary and supplementary evidence have not changed. I would like to first make the following comments in relation to the supplementary section 42A report. I didn't make these in my supplementary statement as I was following the direction of the minute, which referred to the amended plans, but I'd like to speak to these now. So paragraph 36 of the 42A report indicates that the decks for units 3 and 4 are 3 metres from the eastern boundary at their closest point. I'd like to state this is incorrect, as sheet 5 of the amended plans shows the decks of units 3 and 4 are in close proximity to the 1.5 metre setback line shown in dash. In my view, this downplays the extent of setback non-compliance for these units. In paragraph 61, the discussion of shading and privacy effects considers a 5 metre building setback as appropriate from the eastern boundary, and this is used as a comparison for shading effects. I do not consider a 5 metre setback as an appropriate comparison, given the minimum setback in the plan is 15 metres. In relation to privacy effects, I disagree with the commentary in paragraph 71 that the units overhanging the water have accepted similar or lesser setback distances in relation to the other units within the marina complex, therefore providing a useful benchmark for what is acceptable in terms of privacy effects for each of those neighbouring units.
In my view, the marina development is a comprehensive land development specific to their site. It does not reflect the benchmark for adverse privacy effects from other neighbouring sites. And I reiterate that the Section 42A report position is inconsistent with the decision-making of RC190162 for the same site, which considered the same rule framework for multi-unit development. Our resource consent was declined there for a 2-unit development on the basis that the effects would be more than minor. The proposal was of a scale that would not complement the character of the neighbourhood, and it was contrary to the objectives and policies. I note this is an inconsistent piece of in the decision making. To summarise, the key points that I have addressed in my evidence that I see are an issue, the significance of the lake margin setback, the reference to the site as a transition zone, potential amenity and privacy effects, and inconsistency with the direction and the objectives and policies of both the Plan Change 19 provisions and the operative district plan. In my view, the non-compliance with the lake margin setback is significant. It's approximately 13.4 to 13.5 metres of non-compliance for units 3 and 4. The deck of unit 5 is approximately 6.2 metres from the eastern boundary at its closest point, so approximately 8.8 metres of non-compliance. I note that's approximate as I hand measured that with the ruler as they weren't marked. In my view, this setback breach has been downplayed by the applicant and the council planner in the reporting provided. The lake margin setback non-compliance will significantly affect the openness of the northern end of the lake and would likely impact the extent of shading when compared to a permitted built form. In my view, the concept of the site as a transition area, which has been relied on in both the applicant and council reporting, is an arbitrary term and is not well founded in the planning provisions. I consider the duplex buildings are contained to the units overhanging the marina. I consider this site as more closely connected to the adjoining residences along Perriam Place and Foster Place due to the topography and the sites not having an overwater element that is a key tenet of the duplexes. The amended plans show new balconies on the first floor of units 3, 4 and 5 that are oriented towards the residence land. There are potential adverse privacy and overlooking effects that were not previously considered, in addition to the concerns around privacy that I've raised in my evidence in chief. The first floor balcony of unit 3 is oriented directly towards the residence land, which I do not consider as consistent with the recommendations of Ms. Eaton for screening to redirect views away from the adjacent property. In my view, potential privacy effects have not been mitigated. My conclusions are that the cumulative impact of the district plan standard non-compliances provide a development of a scale that is not appropriate for the character of the area. The potential adverse effects of the proposal are more than minor in relation to the amenity values of the neighbourhood and the neighbouring property. And the amended plans are inconsistent with the objectives and policies of the district plan, both the provisions operative at the time of lodgement and the relevant Plan Change 19 provisions. To answer any questions.
Thank you for that. I'll hand over to my colleague to ask the questions, additional questions.
Thank you, Ms. Clifton. Following through your summary statement, where you've discussed there about the setback and what represents an appropriate comparison.
Yeah.
And you're saying that a 5 metre setback is an appropriate comparison. You do not consider that the 5 metre setback is appropriate, given that the minimum setback is 15.
Yeah.
What would you arrive at as an appropriate setback?
I think it depends on the built form. So I accept that it's a restricted discretionary activity and therefore anticipated that someone could make an application for non-compliance, but I don't think it enables built form entirely within the 15 metre as we would consider a permitted activity. So it comes down to the merits of the application proposed. And in this case, I think there is built form across 3 of those units that comes close to the boundary. And I think that's an unacceptable level of compliance.
Thank you. So you would accept that there is a pathway there for
Yes,
to breach that
for sure.
But based on the merits of this proposal, you've arrived at that being inappropriate.
Correct, and I don't think a 5 metre has any weight, as that's not in the planning provisions.
Thank you. Thank you. It's a paragraph, subsection C. You've talked about the privacy effects there and the whether or not it's a useful benchmark for comparison of the units overhanging the water. And you've stated that in your view, the marina development is a comprehensive land use development specific to their site. It does not reflect a benchmark. And you would have heard our conversations over yesterday and today around the fact that it's within the same zoning. In terms of the LLRZ.
Yep.
So in that sense, it's a matter that we've been, I guess, grappling with in terms of we've got the same zone, we've got the higher density, we've got the marina development, a cafe and car parking area, and yet you're saying that I guess what I'm interpreting here is that you're saying that that's actually not useful in terms of just defining the character of that environment.
This statement here is more related to privacy. My reading of the commentary was that each unit owner has accepted a lesser level of privacy given they have a reduced setback from each other. That was my reading there, and the direction from the planner in the 42A report that became a benchmark for what they've accepted as private in terms of privacy effects.
I see.
And I don't think that goes beyond their site.
I see. Yeah. Thank you for talking me through that. That's clear. Thank you. In subset D there, the previous resource consent at that site, which considered the same rule framework, when was that decision in relation to PC 19?
That was in 2019. I don't believe PC 19 had come in yet.
Okay. So when you say that it was considered within the same rule framework, what do you mean?
For the multi-unit development rule that we are working with on this application, noting that PC 19 has changed.
Okay, thank
that, but the same rule for multi-unit development.
I'll just interject another question on that topic. I'm curious, and I'll have to go back and read the decision, but you say it was for a multi-unit development, but it was, the consent was declined for 2 units.
Yes,
The
so
total, yeah, 2, 1 on each side.
duplex, one on each side with a subdivision through the middle. And that was on the 9 Perium place, I believe, the closest to Foster Place.
So
a density of 2 units and a subdivision into 2 lots was declined there. And I think there's an inconsistency in the direction of the planning assessment here that I think is worth noting.
So, yeah, I'm just curious as to what we've heard from submitters is that 2 units would be appropriate. Instead of 6, you should have 2, but consent was declined for 2.
On the single site, so on number 1, 2 on 1.
Okay, so that, yeah. Thank you.
There's 2 on the one side.
In terms of the transition area, you've mentioned in your view it's quite an arbitrary term that is being applied to this proposal and is not well founded in terms of the planning provisions. The term has been used by the specialist urban design input for, I believe, consistently used between both the applicant and the Section 42A input. So in terms of the use of that term, the term transition area, would you accept that that may have some solid urban ground footing?
Maybe from an urban design perspective,
yeah.
I'm grounded with the planning lens, but I don't think it sits well in the planning framework.
Yes.
There's no reference in the zoning or any bespoke provisions related to that underlying consent or otherwise that create a special arrangement for this site or suggest a transition from a planning perspective.
Yes.
I respect that the urban design experts have their own expertise,
yes.
and that it might have grounding from an urban design.
Thank you. So what I'm hearing is that there's no policy support for a special transition zone. There's nothing that would suggest that the site should be treated differently in your view from the surrounding RZ.
Correct.
Thank you. In terms of your conclusions, in paragraph 9A, you're talking about the cumulative impact of the non-compliances provided development at scale that is not appropriate for the character of the area. And again, that brings me back to this, the character of the area. Does the character of the area include the marina development, given that's within the same zone framework under PC 19?
Yeah, I think the marina development is part of that neighbourhood. That does appear as a higher density when you look at the duplex form, but the lake area is still within the private land holding of that site and the underlying development. The actual density, I think Mr. Naylor spoke to it yesterday, is a lesser density than we think based on looking at the units alone. It's all one large land holding,
Yes.
and those are unit titled within that.
Yes.
So I think strictly speaking, the density isn't as high as you might assume by looking at the built form in comparison. I think the site here visually, when you drive into Perriam Place and Foster Road, it sits on the corner and you then look through the site to the resort area.
Yes.
If the built form is on that site, that would change that view into the lake area.
Yes.
And at that point, I think your closest indicators of the character of the neighbourhood are the housing on either side, which is low density standalone dwellings of a character that I think is consistent along those edges.
Room and Foster, isn't it? Yeah.
And then this built form will be seen in that context.
Yes.
It would be from the lake side or approaching from the other direction that you see the back sides of the lake resort. And I note that there are large buffers. There's the car parking area and then a large grass berm and then the road reserve before you have the housing on the other side. So I think when we look at it, when we stand on the site and look at the resort, we do see a higher density visually, but that's contained within a large site that actually reduces the density, and then we see the character of the wider area this would sit within.
Yes.
Yeah, thank you. Just, yeah, I took your point that this development will close off the openness at that northern end of the lake. And I'm just looking at an aerial photograph. I can understand the point you're making. But my question is the balanced piece of land, the small eastern bit, I think it is, it's not built on. The 15-metre yard would also apply to that site, wouldn't it? So have you run a rule over that to see whether that piece of land could still accommodate a unit on there, or would it?
I haven't considered any potential development of that piece of
Because I haven't got the right scale here, but it would be useful to know whether that would render that site under it's part of the wider site, but whether a building could be placed on there to still meet the 15 metres. Because if it was still possible to do that, that would essentially close off the northern view, to at least to some degree from people looking from Perriam Place, from Foster. So yeah.
I'm happy to respond in writing if you would like.
Well, yes, unless Mr. White or someone. Right, it would simply be a matter of drawing a 15-metre yard onto a scale diagram. Whether that's still possible, accepting that the person could still apply for a dispensation.
And I guess technically that's within the lake. Like that is the property boundary that includes the lake. That's part of the lake margin.
That's right. Yeah.
At that point, so I think we would need to think about that carefully.
I thought I'd ask it now because it followed on from that question. Thank you.
Final question from me around the objectives and policies of the PC 19 provisions. So you would have heard us talking to Ms. Mackay earlier and also done yesterday about their planning conclusions and evaluations on those. So you'll see here that you're of the opinion that the proposal is inconsistent with all the relevant objectives and policies.
Yep.
So we heard from Ms. Mackay earlier, who I think that I believe mentioned that she felt that there was some consistency with, I believe, LLRZ 02 and perhaps LLRZ 03, I think, from memory, or P1.
I think
Do you
01,
remember that? Yeah, 01.
I think 01 and P2.
P2.
These are the references that Ms. Mackay and then I believe Ms. Mackay was of the view that contrary to the rest of the provisions.
Yes. So are you
And I agree with her, and I maybe should have made that clearer in there. I didn't reference those two.
Okay,
But I agree that LLO RZ01 provides for the zone to provide primarily for residential living opportunities.
yes,
So this is consistent with that.
yes,
I don't think it's consistent with LLRZ02, which talks specifically to the low density living environment, low rise detached residential on large lots, open space, etc. And then continuing through, I agree with Ms. Mackay that it is consistent with LLRZP2 because it does provide for a range of residential unit types and sizes to meet diverse and changing residential demands. But the remainder, particularly P1, where it talks about providing reasonable levels of privacy, outlook, sunlight, the aspects that I've discussed in my evidence that I think is contrary to those.
okay, well, that's useful to hear your view on those particular provisions. Thank you very much.
Thank you. Just one final question that's been well traversed. Just again on that 9A, the cumulative impact of the district change standard non-compliances provided development for scale not appropriate. I was just curious, are you talking about the cumulative, that there's too many non-compliances, or are you talking about the effects that arise from those non-compliances?
I mean, I think both. I think if we were to look at a height breach on its own, for instance, in a particular part of the site, that might be appropriate. But here, the height breach across the board, I think, is inappropriate. And we've also got the setbacks and a number of factors that work together that I think it's the non-compliances together and then the effects that I've addressed through my evidence. I think the cumulative impact of those also is unacceptable.
Yes, because I think I traversed that with Mr. Dunn yesterday and with Mr. Weir, that there are a number of non-compliances, and the sort of message I got was that they can all be mitigated. But I think the point you might be making is there's nevertheless quite a range of compliances that, together with the effects from those, draw you to the conclusion that it creates a development not in scale, not appropriate character for the area. I understand that. And, I think that's all, and thank you very much for your evidence and summary. That's all we've got. Ms. Appleyard, all the questions we have. Thank you very much for this witness.
Thank you.
Yep.
Yep. Steve, are you there? Would you like to take yourself off mute and turn your camera on and say a few words?
Yes, love to. Thank you.
And perhaps just introduce yourself and explain where your unit is to help the commissioners.
Certainly. I'm just trying to get the camera on. Sorry. Oh, it's not letting me.
If you can't get the camera on, we can hear you perfectly. We can imagine what you look like.
It's probably best you don't look at me. Good morning, everyone. Yes, Steve Brentfall, I represent myself and my wife, Nicola. We're in Unit 19 of the villas, so we're halfway down on the, what would it be, the eastern side? But my points are really just about the asset and the value to the community that the resort brings. And you would note that I made some comment around the pathway shading, and I just wanted to address why that came about. I've picked up a couple of people off the ground after falling in winter cycling, so it is an issue. And I think you need to consider the large number or how often that is used, not only over summer, but in winter breaks. There are kids always playing through there. There are cyclists, they're getting cyclist tours that come through there. They all make their way from that side of the resort through the pathway round to the cafe or restaurant. We see that in the mornings and right through the day. So when I heard yesterday that that we could put the proposed 6-unit development, we could ignore the 15-metre setback from the boundary being in excessive height on an already elevated section, in my view, is being reckless with the truth at best, and it will put many pedestrians at a higher risk. We have some accidents there now. Any building such as proposed will actually make that worse, and I fail to accept the developer's point that it would have minimal impact. I also want you to consider the asset that the resort brings. I think you should give it some strong consideration, particularly to the aesthetics, to maintain some semblance of the resort as set in a semi-rural environment, because that's the feedback that I get from many of our guests that we've introduced to Cromwell and have now, in some cases, purchased land and now frequently holiday down there. It is a value to the Cromwell community. It's not just a business, it's a showcase. It showcases the relaxed semi-rural lifestyle that can be achieved in Cromwell. And as I said, I've had 2 lots of friends that have got rid of their holiday homes in Akaroa and Nelson that have now purchased land down there. I know of a number of my friends now that choose to holiday in Cromwell from moving elsewhere. So I think we shouldn't, in my mind, we shouldn't throw the baby out with the bathwater. By allowing the resort to be compromised by replacing what was the original view of 3 low-level houses over 3 sections, therefore keeping the essence of semi-rural lifestyle, and replacing it with a block of 6 units that will tower over the resort, which should, in my theory, is 2 to 3 metres if you allow for the elevation, blocking the view from all and removing the essence of the resort, I think would be a tragedy for the community. I'd also just close by saying we heard from this developers yesterday saying that, or suggesting that the long-term site was always destined to be closed in at that end as it's a natural progression. I believe this couldn't be further from the truth. The vision was always to have that end open as semi-lifestyle view that surrounds the resort. All the other properties are like that. And frankly, as an owner, we all signed up when we purchased those units on the basis that there was 3 empty sections and they were all going to be 1 house on each section, low level. So, and yes, things move on, absolutely understand that, but from a owner's point of view and from a community point of view, I think you should give it some careful consideration of what change this proposed development would make for the asset of the Cromwell community.
Thank you. We'll just see if I have any questions. I've got one, Mr. Grenfell. Thank you. You mentioned the vision, the vision of the people who are part of the resort, that the lake, is open and that there's low level development and low intensity development on this site. Is that vision that you have, is that being translated into any sort of documents that you're aware of? Is there anything that's written down about that, or was it brought up in previous consents?
It was brought up from my lawyer when I went to purchase the property.
Okay.
Yes, because it is very important, and a lot of people would say, well, gee, Mr. Grenfell, your unit's not really affected by it, and yes, I would say I've got less effect compared to some of the closer units to the proposal, but every unit owner and therefore visitor would use that vista that opens the resort up. And remember, in my view, the lake inlet is our property. We have to look after it. We have a marina committee that we do some work with. And that is enjoyed by everyone, but it's a key part of the essence of Cromwell being. We're more laid back. It's not a Wanaka. It's not a Queenstown. It's a semi-rural, relaxed atmosphere, which we know is Cromwell.
Yeah, I understand it. I have spent some time looking at that inlet or outlet area. It's very attractive. But just going back to that tongue of land on the eastern side, the balance piece, or the piece that hasn't been built on outside this site, are you aware, as part of the body corporate, I should have perhaps asked the witness yesterday about that. Is there any restrictions on building on that site to achieve that vision that you talked about? Is there any sort of covenants relating to that site so it can't be built on?
So you're talking there's a strip of land, I think, just at the edge of one of those three sections?
Yes, that's right. That's the one.
Yeah. In my conversations with the body corporate, I don't believe that there's any thought of anything being built. What you do have to consider, though, is from a visual point of view, when you drive into the resort, the proposal of those 6 units, which as much as our friends yesterday would suggest was still quite open, will block that view from the water completely unless you drive round the other side of the resort.
Thank you. And Mr. Naylor, I think you're still there. You're the Body Corp chairperson. And do you know if there's any restrictions that the Body Corp has over that piece of land?
Yes. So we can't actually build on it. It is subject to 15-metre setback. So anything that is built, you've got 15 metres on the lakeside, and then there's against.
There's a road setback as well.
There's a road setback, but it's too small for us to build anything.
So it's purely a case you wouldn't be able to build on it with the current planning restrictions.
No, you can't.
Okay.
So it's
All right.
That's sort of an open space.
Yep.
It's possibly bigger than that.
Thank you for that, Mr. Naylor. Thanks, Mr. Grenfell. I've got no further questions, but I understand your point. Thank you.
Thank you.
We got no further questions of you, but thanks for coming on.
Thanks for having me.
Thank you. I just had an email from Ms. Clouston. She had one further point that she'd forgotten to make, and if I think we've got plenty of time, if she could just make that point. Charlotte, you had a comment about trees and shading?
Yes, I just was thinking of it as Steve spoke, as the submission that the Grenfells made talked about the ice on the walkway. He's spoken about that. I note the recommendations of Ms. Eaton in the supplementary report, and the applicant accepted or recommended in the draft conditions around trees on the southern and eastern boundaries being of a maturity of at least 8 metres for screening and softening purposes. I just wanted to flag that that height of tree on that boundary may have additional shading implications on the walkway specifically, which has been raised as a concern. And I noted that the tortilla trees were previously advised not an appropriate species, given that 8 metres may have overshadowing dominance effect. So I just wanted to flag whether those are an appropriate species and the valid concerns around health and safety on the access way.
And thanks for that. And it reminds me that sort of relates to a potential condition if consent was granted. Do you have any other comments? Ms. Mackay had some comments on conditions, which I did take it through. But is there anything else you wanted to raise in that aspect? Because Mr. White was talking about conditions potentially. Yeah.
Give me one moment.
Take your time. You've got plenty of time.
That one was the key point that I had. And then the other one relates to, there's a condition 20 that's in Mr. Dunn's revised version, and that is around the 1.8 metre height screening on the units 3, 4 and 5. That only come into play if the if the vacant part of the adjacent land is developed upon. And my position in relation to privacy effects on the neighbouring property and then amenity effects in general of having those outdoor areas near the boundary, I don't think those have been mitigated by these.
Right, so you're concerned about the next property, you're concerned about the wider sort of impact.
Yes, and I think in introducing screening of that's 1.8 metre high above a deck level that's 1.5, say, not marked, but deck levels that are raised, and then the drop down to the land drops away, and then the pathways below it and the lake there. I think we start to introduce other elements of visual dominance or built, although maybe soft, it leaves it open. I think there's some uncertainty in there that should be worked through.
All right, thanks for that. All right.
Thank you, Joe.
Thank you. I wasn't going to take you through my legal submissions, given the dialogue you've had with Mr. Gresson this morning, and obviously things have moved on a little bit, given we now know about the consent memorandum, which I'm much obliged to him for pointing out. And in my view, that consent memorandum just means that greater weight should be given to PC19, because we're that one step further closer to final content. I had in my submissions referred you to a decision in Sade, I think, which did have some similarities in terms of what you do when you face this type of situation with plan changes coming in through the process of a resource consent. So there is some case law authority there. So I'm happy to answer any questions on that over and above what you put to Mr. Gresson this morning, but I think he did a pretty good job of that. And the only other comment I wanted to make was in relation to a question the chair raised with Mr. Gresson regarding Mr. Garda-Hopkins' argument that there's some alignment between specific rules in the operative plan and PC19. And my answer to that would be the same as Mr. Gresson's, that doesn't remove the Commissioner's obligations to undertake an assessment of the proposal in light of the policies and objectives of the plan and the higher order documents. And it's not open to the Commissioners to adopt a compartmentalised approach of comparing rule by rule. That's not the way you go about an assessment. I think that's essentially the same answer that Mr. Gresson gave this morning. So I'm happy to answer anything that wasn't covered with him that was raised in our submissions, but I didn't want to duplicate what he's done, particularly given the fact that the consent memorandum has now moved the dial slightly.
Yeah, no, thanks for that. Yeah, we appreciate the position we're in. We're normally, I think it's fair to say, in the normal course of events with a plan change that's well advanced, very well advanced, you would naturally give it quite a lot of weight. But we've still got this appeal that relates directly to a density standard and a policy, and it's not resolved. So that's where we're at. We'll have to work our way through that. But we welcome those written notes from Mr. Gresson on that, and you're fully in alignment with him, is what you've said.
Yes, and I might liaise with him and just we might come back with a joint set of notes on that issue, because I'm aligned with what he said, so there's no point me labouring the point again.
No, that's fine. Look, fully accept that. Questions today? I think we're okay. Think we've got no further questions.
Thank you for your time. Thank you, and good luck.
Right. Okay. Thank you very much. All right. We'll take an adjournment now, folks, for a cup of coffee, and we have allow plenty of time to go to the local cafes and order your coffee. So we'll make it. We'll come back at 10 minutes to 10:50. Thank you. Right, we'll reconvene the hearing, folks. Everybody's online is listening. Right, we've now at the stage where we're going to be reporting team, reporting officers from the council. And Mr. White, you've got Hannah. Yes, thank you for coming along. And we've also got Ms. Eaton online. Okay, I think what we should do is start with Mr. Hannon and just ask him a couple of questions, and then he's welcome to leave if he wishes. So
If I can also add, if the panel had any consistency in approach questions,
Yep.
that Mr. Tim Anderson, team leader planning, is also in the room. That was something that Ms. Mackay touched on,
Yes.
and he would be best answered to answer those questions.
Okay, understood. Yep. Mr. Anderson, yep, thank you. We'll come to you. Thank you. Thank you, Mr. Harman. You may have heard some of the questioning, but basically there's two things really. There's the traffic or transportation issue, and there's the servicing of units 3 and 4. So that the other two things. And in terms of traffic, we've had evidence on that. And one thing that came up, and sorry, first of all, can you confirm you're satisfied with the traffic and transportation arrangements for the amended plans? Yeah, okay. And we heard from one of the submitters yesterday, there's a bus stop that's located outside the corner property on Herium and Foster. The submitter said that, there could be some potential safety issues with children getting on the school bus. Is that something that should be of concern to us, do you think, or to you?
I have since heard that the school bus collects and drops off children at the car park further north along Perrin Place.
Is it? Okay.
Which is about 120 metres distant from the subdivision, from the development.
Okay. Right.
So I think it has little impact.
Okay. Okay, and just in terms of units 3 and 4, we've had quite a lot of discussion about the servicing of those, whether they be articulated or pressure on-site solutions. And we understand the position of the applicant is that council's normal process is to assess those things as a matter of detailed engineering design at the next stage, if you like. But the submitters have said to us it's something that should be sorted out now, it should be resolved now. But, have you got any comment on that? That's the normal way it's done within council, is that right?
With the recent reforms, our approach has changed somewhat, particularly with the reforms going as long as they have. Our preference would be that it's confirmed prior to issue of consent rather than at a detailed engineering design.
Prior to issue of resource consent.
At this time rather than.
And what are the reforms you're talking about? Are they what are those reforms?
The ongoing, I suppose the legislation was put in place, was it 2022, 2023?
What legislation?
National water reform.
Oh, okay, the water. Is that freshwater or is it something else?
3 waters.
3 waters.
Water, wastewater, and potable water.
Okay, so what you've just said is new, I think, because up till now, you seem to have accepted a condition that would allow it to be dealt with at the design stage. Are you saying that it's not now the practice? Not now the way you do it?
Yes.
All right, I'll ask another question. Sorry, are you about to answer? Okay. Can I ask you what would be involved in if the applicant was required to get that certainty now? What would you expect to be done in terms of the extent of work they would have to give to you? Is it a very expensive, long-winded process, or is it we've got no idea, so we just rely on you to give us some advice on that.
It would be having a surveyor take the levels of the wastewater mains.
Yep.
In Perrin Place and possibly Foster Place. Probably Foster Place and Perrin Place, near to the development, and then calculating based on minimum forms based on subdivision code of practice,
Right,
for wastewater laterals
right.
to the locations of units 3 and 4 from
Right.
those mains.
Okay. And is that a big job? Like, to detail it?
It's essentially the detailed engineering design that they would have to do anyway.
And what would be, is one question on that, thanks for that. If they were able to, if they had to do an on-site solution, is there any environmental risk that comes with that compared to a reticulated system? In your view?
There is a slightly greater risk of, for example, a wastewater overflow in the case of a very poorly maintained unit.
Slightly greater risk, yeah. All right, I think that's probably as far as we can take that. All right, and thanks for that. We've got one further question on traffic.
Thank you. It's taking you back to traffic. We did hear from Mr. Perriam yesterday, and he expressed some concerns in relation to parking on Perriam Place, and he mentioned his view that there was a blind corner and that there was some safety issues with parking on Perriam Place. Were you here? Were you able to listen? Were you tuning in yesterday to Mr. Perriam's concerns? Or?
I was not.
Okay. Is that something you're focused on in your assessment in terms of parking and safety?
I primarily considered the parking provided within the development.
Okay. So have we got any assessment around the on-street parking available to us in relation to Mr. Perriam's concerns?
I do not believe so.
Something we could perhaps return to the applicant on.
Thank you. Thanks for coming along. We have no further questions at this stage, so you're welcome to stay and listen, or you can leave if you wish. But thank you very much, Mr. Hannah. Right. Yep. Now we'll probably go to Mr. Anderson now, because we might only have one or two questions. So, yeah, Mr. Anderson, if you'd like to come shortly. Yep. Thank you. Maybe swap seats. Yeah. Thank you, Mr. Anderson. You're the team leader planning, is that right? Yes. Oh, very good. Thank you for coming. Are you prepared to say something, or would you just want to take questions from us, or have you?
Yes, I'm quite happy to take questions.
Okay. I think, as I understood it, the only question or issue was the net area and the way net area, site area is interpreted for access strips and rear sites and the like, and whether that impacts on the coverage calculations. But have you got any comment on that? Whether it includes a normal site or it's only applying to a rear site? I'm sorry, I didn't realise you hadn't. I thought you'd been brief, but you hadn't. It's just a question out of the blue for you. Was it? Sorry.
It is, sorry.
Oh,
Yes.
okay. Look, that's fine. It's probably unfair to put you on the spot there, but maybe we can take you and design witness, and then you two might go into another room and discuss it. But basically, the what we're interested to know is whether the net area calculation or calculation for a site applies to rear allotments, the access strip being excluded. That's pretty clear. It does apply to rear allotments, but does it also apply to standard front allotments, where you just have an access within the site? It's not a dedicated strip; it's just an access within the site, and that's I took it to be that the submitters are pretty well accepting that, but we just wanted to be sure that's how the council interprets it. So maybe take some time, unless you can answer it now.
Sure, well, I'm not aware of any separation of the access for a front allotment in the allotment area calculation, but
Right. Okay.
while the urban designers speaking, I could perhaps go and seek a little bit of clarification. on that.
By all means, yes, do that. Okay. Very good. Thank you, Councillor Anderson. Right. Thank you. Yeah, we'll go to who's this? Ms. Eaton, you're online. Thank you. Welcome to the hearing.
Kia ora.
Have you tuned into some of the discussions today? Well, thank you.
Yes, I have. I was on yesterday. I was listening yesterday too. Yeah.
Very good. So we won't go through your report and ask questions on every paragraph, but just one of the key things that's come up is you appear not to have assessed the Plan Change 19 objectives and policy framework. And I suppose one observation might be that there's some similarities with the operative plan, but that's my words, not yours. So I'll just ask you to respond to that, maybe. Thanks.
Yes, thank you. I had a brief conversation with Mr. White earlier around this matter. So you are correct that I didn't undertake my peer review in the context of the LRRZ policy and objectives. I was asked by CODC team to assess on the basis of RRA3, given that's the currently operative plan. However, in looking at the objectives and policies from LLRZ earlier, I think, in my opinion, from an urban design perspective, they are essentially the same. And other than obviously the lower density provision and possibly character. I note that part 3 of the LRRZ objective talks about maintaining anticipated amenity values of adjacent sites. And I think this brings me to possibly one of my key points of my supplementary report and thinking is that, in my view, whilst the character of the surrounding area is suburban, predominantly suburban, Marsden Resort does provide a higher density character. And I think it was touched upon yesterday as well that the proposal relates more, in my opinion, to the character and form of the resort, given that the proposal is separated from the lower density development by Pyrian Place and Foster Place. I think there was a comment made yesterday that essentially the proposal is ring fenced by these two roads, and therefore, in my view, the relationship of the proposal needs to be considered in the context of it being adjacent to Marsden Resort. And not only the apartments within Marsden Resort, but also the associated car stand, the parking, the commercial activities, etc. I know Mr. Weir talked about it being urban in character. I wouldn't agree with that. It is higher density, though, noting than obviously the houses around Pyrian Place and Foster Place. Which brings me to my main point, which is that my main concern, as outlined in my supplementary evidence, was ensuring that there is some relationship with an integration with Pyrian Place and Foster Place. And also maintaining the visual openness that's characteristic of the surrounding lower density properties.
Yes, thank you for that summary. That's useful. So you put quite a bit of weight on the resort as being, existing part of the existing environment, and it doesn't seem to be reflected in the provisions. That there's no recognition that I can see or that anyone's been able to point to.
Yeah,
in the provisions, but it's nevertheless part of the environment, isn't it? So that's your
it
point.
is. Yeah, I think it's maintaining anticipated amenity values of the adjacent sites, and I would argue that the resort is the most adjacent site, is the most critical site that's adjacent to this proposal.
Yes, right, and so does that lead you to the conclusion that rather than replicate the result on this site, which would be going too far, I suggest, you see a sort of middle ground in some way, and you
Yes.
think, and your evidence is that these 6 units can be accommodated in terms of density, subject to modifications that most have been met, but not all have been met in relation to the street interface and other capital living spaces that summarises it.
Yeah, that's correct. And it's, I know to Mr. Weir's evidence, he talks about passive surveillance. And whilst that is important, in my view, the most critical amendment that could be made is actually providing pedestrian access from the streets to the units via having front doors visible from Perrine Place and Foster Place and having pathways to those front doors.
And did you hear the discussion today about the northern part of the lake and the sort of vistas, looking from the street down into that northern aspect of the lake? Do you see that as an important to be maintained, that's still in the lake?
To a certain extent. However, I would consider that as you come into that development, the view across the lake is one that I think people have got used to having because the site hasn't been developed previously. So I think it's, whilst it isn't something that I've actually considered, but that view wouldn't, regardless of the height of the proposed development, even if they were single story, more suburban in character, that would still obscure the view across to the lake in some way.
So yeah, I understand that. So the 15-metre yard setback, we've been told by submitters that's important. That's really important in this location. It can be varied in other locations, but in this location, it does provide that buffer and or at least that view into the lake. But any further comment on that?
Not specifically. I'm looking at the plans now and I see that there's a setback from the road, Foster Place and Perrine Place, and then there's the 4.5 metre boundary setback as well in terms of the development. I think that's sufficient in terms of maintaining openness. I do note that it is built right up to the boundary on the eastern and southern side, and I will have provided some comment around that in my supplementary report about how that could be potentially softened to that edge.
Oh, okay.
But I don't consider that 15 metre setback as critical as some of the submitters.
All right. Thank you for that. I understand that answer. So this is all questions.
Thank you. We heard from Ms. Liston today, and in her planning evidence at the end of her delivery, she added her concerns around the height of trees and the concern that this may create additional shading impacts on the walkway. Were you tuning in at that point?
I did hear that, yes.
Yeah, do you have any comment to make in relation to that?
Yes, in my supplementary report, I noted that I didn't think Totara species was appropriate. They are, and then it got replaced, I believe, by Pittosporums. And I don't consider those to be appropriate, as I noted in my supplementary report, primarily because they are, well, 2 reasons. One is that they are evergreen, and so then would create shading issues in winter. And the other is that they can get quite large and be quite hard to maintain and bushy. My recommendation was, and having been to the site a number of times, was to propose, and again, in keeping with my recommendation about integrating this development into the surrounding streetscape as much as possible, was to propose the use of some form of prunus species. And those prunus species are currently used within the existing streetscape, as you probably would have noted. These have the added benefit of being deciduous, so would lose their leaves in winter and therefore would provide less of a shading issue.
Thank you. That's helpful. Thank you.
No, look, that's fine. I don't think we've got any further questions for you. We understand your supplementary evidence. We know where you are with this one, so thank you very much.
Thank you.
Okay. All right, okay, Mr. White. Mr. Anderson, are you prepared to answer that question about the area? Yes. Okay. Yeah. Go ahead.
Yes, so the exclusion from access, it applies to the rear lawn, but not the front.
Okay, that's clear. Okay. All right, thank you for clarifying that. All right, that takes us to you, Mr. White. Again, we don't want to go through your report blow by blow, but is there anything you want to address us on from what you've heard during the course of the hearing, and any points you wish to emphasise to support your recommendation? This is your.
Yes, there might be a few things I think that are.
Yep, there's plenty of time to take your time and when you're.
And then I've tried to make a note of the questions.
Right.
Only you've given me.
Okay.
But I might not answer them in a particular order.
That's fine.
Just in terms of written approvals, because that was something that was discussed yesterday, I would just draw attention to paragraph 27 of the section 42A report.
27, yeah.
That makes it very clear that I've followed the clarification provided by the subsequent planning consultant that no written approvals apply or have been applied. So that applies for myself and the assessment of others. So council officers, at no point have we ever factored that into our.
So in other words, you haven't dismissed the effects that might occur on the resort. You've still.
There's no written approval was ever obtained.
All right.
Yeah.
Okay.
Yeah. So just to make that very clear.
All right.
I did notice in terms of the correction to the supplementary section 42A report, paragraph 44, it refers to Sugarloaf commercial limit, which should be limited. It's a company entity.
That's all right. I think it probably
there's been some discussion of minor residential units, just following up from Mr. Dunn's statement earlier, raising the potential for 4 separate household units. I just want to make the point that the minor residential unit has to be ancillary to the residential unit. So what you've effectively got, you may have 2 separate buildings, but they're the same household unit. So the build form could change with a minor residential unit, but the household would be, in terms of permitted baseline, 2 households per existing.
What impact would that have, do you think? How's that important, I guess?
Just because it's also something that was picked up in Mr. Gardner Hopkins' statement, is that clarifying a permitted baseline and the effects between what is proposed and what is allowed for, anticipated under the plan provisions. So it will have an impact on build form. You could possibly see 4 separate buildings on the application site, as long as it meet the.
Right, so it can be internal, it can be external, but if it's external, it results in another building.
Yes, and then you'll be subject to the site coverage requirements.
Yep.
But
okay. So
just in terms of comparing 6 units versus what could be built.
Yep. Okay, and while we're on that point, the Ms. Mackay's evidence about potentially having minor units, is your understanding is that if a consent is granted for this development, that's where the consent stops, and any further development would be subject to a change of conditions or a new consent? So is that how?
Yes, I was going to follow up on that point too.
Okay.
And I definitely agree the suggestion that you make internal modifications to achieve something else isn't fanciful, because if you look at the summary table that applies to the Marsden Lake Resort, they applied for a change to consent conditions, or effectively a resource consent that modified another consent to allow for visitor accommodation in each of those units.
So it's not fanciful, but it would require a consent.
Further consent
okay.
or a change. Yeah.
All right, understood. Thank you.
So it's not a case that you could just make some internal changes as a permitted activity.
Right. Okay. All right, thanks for that.
Something that was also raised in relation to RC190162, which was the duplex units on 9 Pyramid Place.
Yeah.
The very section that Ms. Mackay referred to is in my supplementary statement at paragraph 40, which added that clarification that it was also a subdivision consent, but the panel made the decision very clear that even if they were only considering a land use consent, they would have reached the same conclusion about intensity.
Right. So you're essentially agreeing with her take on it. So,
Yes, but in terms of being a summary of the position at that time.
yeah. Okay.
Yes.
So they were concerned at the intensity, regardless of whether it's subdivision or land use. It still is.
That's right. They said even if subdivision wasn't considered.
Yeah.
Yes, as I say, I pick up the exact same.
And so what, and I guess the point that was made there was that why have you not put some weight on that, or why do you come to a different conclusion to what the panel did in that case for 6 units on the site? So what's your answer to that?
I touched on this in supplementary evidence.
Okay. Yeah.
That the distinction, while they're not necessarily bound, I mean, it's good to be consistent in terms of approach, but they're not necessarily bound.
Oh, absolutely.
But in these proceedings,
Yeah.
the specialist in design assessment that's been provided,
Okay.
it wasn't at the time of the RC one.
That's right. I do remember you saying that. Thank you for reminding me. So I understand that point. Thank you.
In terms of lake boundary setback and whether it would apply to the balance area of the Marsden Lake Resort, that it's something I've briefed Tim Anderson, Mr. Anderson, better on, and I apologise for.
Oh, okay.
And I was trying to multitask.
Sorry, I
Correct.
didn't realise.
I didn't intend to be too disruptive.
I didn't realise you had another point. I didn't need to chop you off, Mr. Anderson. You had another point, mate. Okay.
That Mr. Anderson provided clarity that when you talk about future development in that balance area, the Marsden Lake Resort, it would be subject to the same, we're called by the same rule in terms of 15 metre yard setback.
Right, okay.
Future building.
Yes, it was still applied.
Yeah. I did discuss specifically there's differences between the LRZ standard and the residential resource area setback in the wording. The latter talking about within the setback or as distinct from the setback. But in terms of the general approach, the reaction was the same 15 setback would prevent development of that site. I also touched upon it. It would require the approval of all of the common owners of that land for a future development, which becomes harder once you get 1 or 2 to get agreement. So in relation to the issues of privacy, this was something that was discussed, that what they've accepted at their own resort isn't necessarily what they would accept from neighbouring sites. But all things being equal, that was my general approach, is that if they're satisfied with that level of privacy, and then what I would, and I talked about the actual setback distances in the supplementary statement. I thought that was a reasonable indication where benchmark was referred to. What I would also note that visitor accommodation change or additional resource consent for Marsden Lake Resort provided for studio units directly above each of the unit titles, so that you've got your main unit.
Yeah, I've stayed in one of those units. Yeah.
And you've got 2 units, and I had a brief conversation with my neighbours across that barrier yesterday, so that they look directly down on top of that double balcony area. So there's a difference of opinion, obviously, in relation to.
So yeah, I've just got to capture that point. So I think what I understand you to be saying is that the residents of the resort are happy to tolerate a certain degree of privacy intrusion. Is that fair?
From their other fellow
from their
residents.
term, if you like. But and so how should we translate that to this the effects of this development? What are you saying there?
So I'm saying I would treat them equally, and then you've actually got greater setback distances from the proposed development. And
Greater set.
similar level of, well, actually a better level of privacy.
Right. I see what you're saying.
That's still my view. I will come to the recession plans because that was a specific question you had. But just briefly, the observations made about shading of the path, if you look elsewhere in that development, there's shading that occurs from the existing buildings. And so I don't see that as materially different. The question relating to recession change that the panel had. If you look at the residential resource area,
Yes.
it's rule 7.3.6, Roman numeral 3. I had written down F here, but if you look at the reasons for the recession plan in that operative plan, it's stated under heading reason, and it says separation and height controls maintain and enhance amenity values of the residential area. They also assist in reducing the impact on neighbouring properties, access to sunlight and privacy. And the quick observation that I'd make when you compare that with the height in relation to boundary rule of the LRZ is it's quite more specific and broader. It isn't solely dealing with amenity and sunlight and privacy. It's other things like dominance, views. It also starts talking about you could encroach if there's a reason relating to a natural hazard to it, encroach, those kinds of things.
Sorry, just to clarify, that last statement you made, is that in relation to the operative plan or the?
Oh, sorry, LRZ.
The LRZ is.
It's broader than the operative.
I see.
So it introduces
Yes.
specific wording that relate. It was this idea of it could be other things other than just shading or privacy. And the LRZ PC 19 makes that very clear. It is much broader than that, than the operative plan did. It looks at views, it looks at dominance.
Does that not then support the submissions, which you're concerned about more than just shading that, concerned about immunity?
Development matters.
Right, so does that influence your judgment in any way?
I've still considered.
Right, you've still done it. Okay, that's fine. Just need to clarify that. Thank you.
The other point I would make is that, and I think Ms. Eaton touches on this, or at least this was an element of our discussions, is those gable ends provide visual interest, and they sit at a point in terms of ridge lines where it's of no material difference. And I think the shading diagrams help demonstrate that. But what I would also point to in the LRZ exceptions actually allow for gable ends to intrude up to 1.5 square metres.
Right.
And I'm not sure that that is captured accurately in those coloured diagrams with blue.
Yeah, so just remind me, as I understand it, the LLRZ standards, including height recession plans, are operative essentially.
They are.
So we should really only be considering those. Is that right? I mean, there may not be a lot of difference, but is that right? Am I right?
Yes, they're deemed operative because there is an appeal relating to those.
Right, but there's still a breach of the height limit under the LLRZ. There's
Yes.
a breach of half a metre or something.
The 7.5 metre maximum height that's exceeded by about that half metre.
So do you think, I'm sure you've dealt with some evidence, but I just need to remind myself, is that not an important intrusion when it concerns the whole ridge line of buildings higher than they should be, or higher than the standard says. And it's an elevated site, and the residents have expressed concern about outlook views and the very things that LORZ now encapsulates with the recession planes and height. I presume they work, height and recession planes work together. Do you not see it important that compliance is achieved with the height standard?
The way I've generally approached all of those matters related is to note the orientation of that closest unit and its small windows.
So you're concerned about one
It's
unit, but not wider.
Well, even in that case, I don't think it's the orientation that's not there. It's not as primary.
Okay.
That was my.
We'll go back. Sorry, we'll go back and look at the evidence on that. But I do remember you did cover that off. But that's fine. Thank you.
And then you've got other units on the other side of the lake that are some distant from it, where a half a metre isn't going to make any difference to them.
All right. Okay for that. Thank you. Sorry, you just before we move on, just
Yes, so we heard from Ms Cliston today, who challenged the comparison you used for shading effect, the 5 metre building setback.
Oh, yes, sorry,
Yes.
I did make a note.
So yeah, what comment would you make in response to?
So Ms Cliston's comment was the dotted line shown on the plans is a 1.5 metre setback from the boundary. So rather than sorry, there's maybe a couple of things. Yeah.
Yes, I think there's a couple of points. So what I'm
5 metres, sorry.
yeah, so here in response to your supplementary evidence or your reporting, that you consider a 5 metre building setback appropriate from the eastern boundary, and you've used that as a comparison for shading effects for what a permitted development might look like on that site. And today she has challenged that and said that 5 metre has no grounding in policy or in the provisions. And so I'm interested in how did you land at 5 metres as a comparison, and do you remain of the view that that is a useful comparison?
Yes. So I've looked at that consent history and I've attached, and there's some good, really good reading in there. There's a lot of documentation in the supplementary statement. And while it might not form part of the existing environment because the consent is left, there's commentary in RC 090205 that for 3 lots within the original development, it was something of an oversight to apply a 15 metre setback to those internal boundaries, and that a 5 metre setback was appropriate. So it may not have any legal standing, but it's very clear that that was the intention in terms of the comprehensive development. And not only did you have the units extending out over the water, there were a number of lots that were granted approval for to breach that 5 metre setback. And lot 20, which is at the border of it's Arroy Close, which is an internal access rather than a legal road. Let's bring up the map. Under the same resource consent, that 09 resource consent, that house was built, and so it didn't lapse because it gave effect to it. What I also observed in my evidence was there are 2 other lots in that development that adjoin, that they have a Foster Place address, that adjoin a boundary where the 15 metre setback would apply, and they didn't apply it, they built. So development, I didn't try to get too caught up in everything, but I tried to look at all of the development in the broader area, focusing in on the questions you specifically had. But just to try and provide an understanding, I think I did provide some very brief comments, that it wasn't an exhaustive investigation, but it's variable in how that has been applied and which ones have obtained a 5 metre setback. The bulk of the development of the original piece of moorings, it was the 5 metre setback that was applied from that land boundary.
Right. And so in summary, there's nothing in the provisions in front of us that require that
It'd be a 5 metre.
that the 5 metres is an appropriate.
That's right.
Right, just to be clear there. Yeah, thank you.
Sorry, maybe that was too long.
Thank you.
But I went off on a tangent earlier in response to a question about what was shown as a line being 1.5 metres rather than.
I use for the units 3 and 4.
Yes.
Yes.
So what I've focused in on is that while it might be what is in my view a technical non-compliance in terms of setback because of those dead areas being higher than 1 metre above ground level, that there's generally an openness that relates to that part of the site, and it's the setback distance. I apologise if I haven't made it clear. I was talking about the principal building rather than the balcony itself. So that's the reason why that might seem that I've applied the wrong measure, scale of plans.
Thank you.
Yeah, just carry on. You've got some other points to make.
The last one thing is in relation to flooding and natural hazards. And I can confirm that under the district plan, there are no natural hazard notations affecting the site. But when you look at the Otago Regional Council Natural Hazards database, the Otago flooding overlay doesn't affect the site.
Doesn't
affect the site, but it is affected by the alluvial fan hazard, which can have impacts in terms of overland flows and also geotechnical conditions. I think that's why it's there. And so I've only got rough notes at this stage, but if it's helpful, I can provide a link to those sections. But
the alluvial fan one, the site's now probably developed, the land was developed, isn't it? So presumably that risk is no longer. I mean, is that an old overlay?
This is in response to yes, it dates back from 2007. Right.
Yeah.
It was being done by Opus.
Yeah, so the alluvial fan's not something we need to be concerned about, is it?
It's just Mr. Perium said, and I think when the whole development was considered, they considered levels, and that's the reason why everything has a finished floor level set as a consent notice, including the application side. So that matter in terms of levels has been addressed. But he talked about how in his own building activity, he was affected by flooding, and told he was affected by flooding.
Absolutely. Yeah.
And so I think there's a distinction there that, in fact, the properties he was talking about are affected by the alluvial hazard notation rather than.
Right. I'm just wondering how real the risk is. That's all. But that's right. We've got no evidence on that. So take note of that. Thank you.
I think that was most of what I had in terms of your questions that you gave me as homework.
Just got one other small question because you might be going on to some bigger matters. But
No, I'm finished.
Oh, you finished? Okay, all right, that's fine. I just had one question about that, and I've asked some witnesses today about that balance land. I call it the balance land, but it's the piece that's not developed, the eastern extent at the top of the lake, the northern part of the lake. Have you had a chance to see where a 15 metre setback and a road setback would leave? Is it realistic to build on that side, or is it completely?
It would shave off
your
large proportion.
Large proportion. Okay. And then presumably there's a side yard requirement on both sides as well. So yeah, there's not much left, is there? But as a planning practitioner, would it be your expectation that a site that's zoned for residential without any sort of hazard overlays should be able to be built on, subject, would it be reasonable to expect a single unit, for instance, on that site, or is it just do the setbacks render it undevelopable?
Yeah, in my view, it's just something you need to assess. It's a trigger, it's not a prohibition.
That's right.
And just related to that, it's still my view that the orientation of the application site, their eastern boundary in relation to the lake margins, I've made it reasonably clear. It's actually quite useful that 15-metre setback also applies to that balance area of the Western Lake Resort, but it maintains that openness, and I think that's enough.
So not there that you're willing to.
And I'm not concerned. Yes,
You're
exactly.
willing to reduce it on this side, but not that one.
That's right.
Okay. Understood. I'll let that use. Yeah, just take a pause for a moment. Yeah. Yeah, that's right. So what we've gone through now is what I might call some detail, but in terms of the big planning principles at stake, and as you've heard from us, the key one for us is weighting of the PC 19, and with thanks for your update on where the appeals are at and that. Have you got any further thoughts on where that? Any further thoughts on what weighting should be applied? Is it something you're happy for us to grapple with?
It's like everything. I'm here since of course.
Yeah. In terms of, as I've said to the hearing earlier, the normal presumption is that if a plan change is well advanced, really well advanced, it's been hearings, decisions released, and there's in this case only one appeal that's relevant, I believe, but it's still unresolved. And so, and then you compare that to an offering plan that's pretty dated and very dated, in fact. We've got to grapple with where to go with that. And did you have any comment on that? I'm not
Sure. Possibly I should have also commented briefly on objectives and policies in terms of plan structure.
Any of those planning issues, you're welcome to talk to us about.
Because I did find it interesting that Mr. Gresson, in answer to that question, felt that even though there's objectives listed for LRZ that aren't marked as red, showing as being operative,
Oh, yes.
that they could also still change because it's still very much there and unresolved with that appeal.
Did you say this?
So objective to, well, that's what I heard him say.
So did you tell us what you think he said?
That's what I thought.
Okay.
Yeah, and then
We haven't got the written notes yet, but I didn't quite understand it. But please tell us what you think.
but then in terms of weighting, maybe I'll deal with the weighting. It's a long way through the process, it is, and there is that temptation to, and this is very much, I think, the last gasp potential development of this scale, because it relies on the multi-unit residential provisions of and the status of activity. But I'm not quite there to ignore at that point where I would ignore the operative plan at this point.
No.
And so I'm still giving greater weight to the operative.
Still going to go to the operative plan, but LRZ02 is beyond challenge, isn't it? Is that?
Well, it's not marked as red, but that's what I thought.
Why is it not marked as red?
Well,
Is red means subject to challenge? Is that what?
yes, exactly. Yeah.
All right. Well, we understood it was the P6 one and also the rule, but
I may have misunderstood.
but the objective, as I read it, talks about a pleasant, low-density living environment. And we've had evidence from Mr. Dunlop, that the sub-clauses contains predominantly low-rise, and he introduced some discussion about coverage and other things there, and he's looked at the things underneath there, but the chapeau talks about the low-density living environment. And
I think we touched on it today. There's some elements there that are quite interesting. Is that, and I touched on it in section 42A originally, because I assessed all objectives and policies, LRZ, operative plan. And I did go back and revisit those when looking at the amended plans, had something changed.
Right.
And I just had a brief comment that I still reached the same.
Yes, you did. Yes.
So item 1 of O2 says contains predominantly low-rise and detached residential units on those lots. So there's an out there. I'm also mindful that this is a 7.5 metre height restriction that allows for 2-storey development.
Yeah.
And there have been 2-storey houses built in that locality along Perion Place.
Yeah, so if we look at the word, predominantly low rise, if you include the resort as part of the environment, that's not low rise, is it? So, you know, there's low rise and there's high rise, if you like, and has anyone done the assessment of what predominantly means in that context? Adding some more 2-storey dwellings to existing environment with quite a few 2-storey dwellings. Is that achieving that objective?
So where I landed is that it would be inconsistent, but not contrary.
Oh, I see.
And so that's in the 42A.
So you're balanced.
That is part of it. Yes,
That's right.
but yeah, in terms of picking up on the point of, well, the same zoning and same provisions apply to the Martin Lake Resort, and it's been considered to predominantly meet those requirements. 2-storey development with reduced setbacks.
Yeah.
Provided the majority remains, but there might be a tipping point at some point that the development no longer is predominantly low rise, but low rise has to mean a 2-storey development because 7.5 metres permitted.
Oh, yes. Thank you. And just while we're on that, we've discussed it with several witnesses. The resort itself doesn't appear to be recognised or acknowledged anywhere in the planning provisions as being, you know, there's no obvious reason why it's been included in this zone that you're aware of.
Now I don't have the full EC19, but yes, I think that is a material piece of information for determining how you land on those objectives and policies.
All right, I think I've taken that far enough. So thank you for indulging me on that. And so that's the. Are there any other wider planning issues? We talked about weighting. That came from the weighting question, but all of that discussion. Is there anything else? That's probably the key thing.
Just an overall statement I possibly should have started with is that I was reluctant to show in approved conditions the plans put forward, even the revised plans, because Ms. Eaton is seeking further changes.
Yeah.
So that recommendation that I've reached based on the advice of others is that it's almost there, it's tweaking, but it's not quite there. And the applicant is still presenting the plans without further change.
So that's right. That's what's in front of us. And in terms of Ms. Mackay's suggestions about some change tweaks to some of the other conditions, I didn't take it through those. But did you have a look at this?
I think there was one that talked about what a right of way is not proposed. In one condition, but it's bracketed sort of with a slash access way right of way. There's nothing preventing that was a condition developed by Mr. Harnan, and it just allows for a range of possibilities.
Yep.
Rather than they are proposing a right of way, it's or an access way. So
Okay.
I didn't see a reason to mess with that.
All right. So
they could revisit a right of way with the sedimentary for it.
Well, we'll ask the applicant to provide final set of conditions that they're comfortable with for us to consider, but they can comment on that as well. But you've got no other comments to make on those.
Or other than, yes, it was Mr. Dunn put forward the screening. There's only one line on those units.
Yes.
In light of what we've said, we've heard about that 15 metre setback that applies in a general acceptance of in the wider development at the original subdivision and land use. for a 5 metre setback, then I don't think that's necessary to put that additional qualification on it. So we can stick with the conditions I put forward.
Those you just stick with the condition put forward. Okay, thanks for introducing Mr. Harness name again, because that reminds me, I took Mr. Harness' response to that question about servicing units 3 and 4 to be that there's a change of position at council on how that's to be dealt with, and are you fully acquainted with that? Because it leaves us in a position where we don't, if that's to be applied, it should be part of this proposal, how it's going to be serviced.
Yeah, I can comment because I've had
Yep.
some discussions.
Okay.
About this with
Yep. All right.
also the 3 words team.
Okay.
So it has taken a long time to get to this point, and from the outset, council engineers have asked the applicant to do that design work to determine whether it is feasible to service the entirety of the development by gravity sewer, but they've declined. They were still maintaining their position. That's for between 42A, that there have been some further changes. The minute from the panel prompted the applicant to get in touch with the council saying, would this be acceptable? This is a feasible engineering solution. And they got some clear direction by email that they would accept it, provided they do their homework. And I think this, the applicant's already covered this, is that prior to that engineering acceptance stage, they actually do the design work to understand, is it possible to service all of it by gravity sewer or not? And the council wants to see the evidence of that working before they get to that point. And so that's a little bit different than as Mr. Harney presented today. They've got a very clear preference for gravity sewer where it's possible. They have accepted low pressure elsewhere. In this particular application side, they want to see the fewest number of units serviced by low pressure gravity systems possible. So it's not like you can't service it entirely by gravity, so we're going to service the whole thing by low pressure.
And what's the reason, Mr. Hammond still here, what's the reason for that? Is it to do with the capacity of the infrastructure, is it to environmental concerns, or both? You know, why is that the preference?
Mostly to asset maintenance.
Asset maintenance. Okay.
I would also add that when there's no subdivision, there's no separate units, it makes it very complicated, as you'll see from the conditions, and making that work, because it's to be established by covenant. It has to apply to the entire site, but only parts of the site.
Yeah, and I just thought of a question that I should have put earlier. Why are we only concerned with units 3 and 4? You know, the other ones beyond, it's a gradient thing, is it, or gravity? Okay.
Yes.
Is it, so it's just 3 and 4? We're
Just 3 and 4. So,
yeah, so yeah, I'm just trying to understand where it leaves us as a panel, because we haven't got that certainty in front of us, and we're up till this point, up till today, in fact, we were under the impression that it's acceptable to council to have a condition to defer this to a later time, even though submitters have said that's not the right way to approach it. But nevertheless, we're in a position now where we don't have that certainty in front of us, and it might be something we need to put to Mr. Gardner-Hopkins to deal with, either in its reply or by separate memorandum. So, yeah, but anyway.
To the best of my knowledge,
yeah.
Up until today,
Right.
that was an approach accepted by council.
Yeah, okay. And we must remind ourselves all this has to relate to the resource management aspects, not the council's own preference for how it resolves and processes things internally. It's what are the effects from an RMA point of view of us dealing with them that way. So, any further comment on that? Or?
I think that might be.
Yeah, okay.
One more question from me. We heard from Ms. FWR today, her legal submissions, and she concluded with the statement that granting consent any granting of this proposal might lead to an undesirable precedent. Have you considered the precedent effect and its relevance to the this proposal?
Yeah, I haven't specifically discussed precedent
Do
fees,
you have any comment in relation to this?
other than each subsequent application will have to be considered on its merits. And
And it's for restricted discretionary. That's
exactly, that's the reason I possibly didn't go into that in my report was the greatest issue is for a non-compliant entity where it creates that ongoing precedent for subsequent applications.
all right. I think we're finished with you. Thank you very much for answering those questions. And I don't think there's anything else to arise from that. So we'll now hand over to Mr. Gardner Hopkins. I think you're on the line. Are you, Mr. Gardner Hopkins?
Yes, thank you. Can you hear me?
Yes, we can. And you would have heard a lot of things raised today that you may wish to comment on verbally now. You're welcome to do that and then do a following up written reply.
Yes, well, look, I've been sort of communicating with Mr. Dunn, and unfortunately, and I'm not sure if it's my end or from the transmission end, I've had a little bit of sort of clipping or interference with the internet connection. So I'm at a little bit of a disadvantage. I think I've got the gist of most of the discussion, but not necessarily all the detail. So look, I'm happy to address you on a number of issues, but as I say, I'm somewhat compromised in some aspects of the detail. And I suppose, look, it's clear that I do need to come back to you on a key issue of the weighting, if we call it that. And there's been quite a bit more discussion around that. And I think the applicant or I need to be very, very clear as to at least our position on that and what we are asking you to do in terms of weighting. What are the relevant considerations? I think I heard that we might be getting some detail as to the current consent order documentation so that we can understand at least what has been agreed by the appellant and the council. Now, obviously, until a consent order is issued by the court, that doesn't change the, if you like, the legal position in terms of the decision's version of Plan Change 19. But I think, and having dealt with this in different circumstances, it is evidence as to what the council and the appellant have agreed to in terms of their position as to an acceptable outcome. And quite possibly represents a bookend in terms of what might potentially change from the decisions version. And so I think it's quite important potentially to understand that detail. And so it seems to me, I guess if we're wanting to use our time efficiently, that it might be better to try and discuss timetable from here out, rather than for me to talk to any great extent about, some of the various other matters, unless you wanted my initial reflections on any particular matter. I think it's probably better that I'm able to confer with Mr. Dunn and his notes and provide something that is as clear as possible in writing on the various issues that have been raised. But part of that is receiving this update in terms of the consent notice from the key submitters.
No, that's a good point. Yeah, because Mr. Gresson did provide a draft, or at least an application for consent order document with his initial legal submissions, and then he asked that they be taken out because they're not finalised. But they are nevertheless quite relevant, I think. And so what I tentatively asked Mr. Gresson to do, and I can follow it up with a minute if need be, is to provide those again, I guess. And with some commentary around his own involvement and where it stands, and that can then be circulated to the parties to help you with your written
Yes.
writing.
I'm not sure. I saw the consent documents. I might have missed them, but they may, if they were provided and then withdrawn, they might not have been circulated.
Yeah, that's right. But it's I think it is relevant to have a look at those again now. So we'll go down that path, and they'll be provided to you. And then you can provide a written right of reply after conferring Mr. Dunn. And if we have a complete set of draft conditions that suit the applicant that we can consider, and that brings me to the point about units 3 and 4. You would have heard that discussion about the council officers appear to have changed position on what's acceptable there in terms of conditions. So if you can either talk to that now or in your right of reply, but it leaves the panel in sort of a quandary as to where we go with that. Yeah.
Yes. Well, look, it's obviously something of a surprise to me and to the applicant. It wasn't entirely clear to me if it was a definitive position from the council's infrastructure person, or whether it was perhaps a retreat and an emphasis on a preference or a strong preference. So, yeah, look, I'm a little uncertain as to whether it is now entirely unacceptable or if it is, I guess, not preferred or strongly not preferred. And so I'm not sure if the particular infrastructure witness is still there. Yes. And it might be worth trying to get some very, I guess, firm clarity. Yes. Or whether that might be a discussion that could be undertaken in sort of an interim period, including if the applicant's engineer were to engage directly on those issues. And I guess sort of thinking out loud somewhat and hearing at least some resistance to where we thought we had got to with this cascading provision, whether the applicant is willing to explore what it will take to do the survey work that would then inform some engineering design, and whether necessarily it would have to be a full engineering design, or whether there could be some, I guess, partial or conceptual design that would give the council engineers a bit more comfort. So I guess what I'm saying is that there's now some thinking to be done, and I'd like the opportunity to confer with Mr. Dunn and the client, the applicant, as to how they might wish to best proceed in that regard.
Yeah, that's fair enough. And I think I made the point that as a panel, we're concerned with the RMA aspects of it, not the council's internal processing and what they prefer. We're interested in why is this important, and I think I understand why it is, but we need to focus on that. And can I just ask the officers while they're here, perhaps Mr. White, you can confer, but I took the position to be that is what's being asked for, a full an engineering design. Now, I'm not sure whether that's a full-blown design or it's some sort of lesser standard of design, but I think Mr. Gardner Hopkins is seeking clarity on exactly what the council's position is on that. Are you able to tell us now on that?
So I was just going to forward on to Mr. Harnan the email that was sent by the Three Waters team. You should have it very shortly in advance, and I can certainly make that available.
So there's a written communication that sets this out.
It's pretty brief.
Okay.
And so Mr. Harnan may be reading that shortly. I can read it out.
Yeah, it'd be useful to have that now. Yep. In front of us.
I sent it to the hearings.
If you've got it, you can read it out to us if it's not too long.
It is pretty brief. I'll send it to the hearing address. And you might even be able to see it over the, they'll forward it on to you. So it says, in response to Alex Dunn's email by Water Development, it was sent by Stacey Coy, who's the Three Waters Development Manager. Hi Alex, I've been speaking with Julie Muir and the council would be accepting of a low pressure system. Would your council, and she had in italics the question that was posed by Mr. Dunn, which was, would your council be supportive of allowing a low pressure system for wastewater disposal for units 3 and 4 to gravity sewer cannot be achieved? We would also volunteer a consent notice condition to be imposed on the title, making it clear that the LPS systems are the responsibility of the landowner to ensure council doesn't have responsibility for these systems. So that was the question that was posed.
That's the question.
Council would be accepting of a low pressure system. And it signed off, please ensure your engineering acceptance plans clearly demonstrate that gravity is not achievable.
All right, so it's, did you hear that, Mr. Gavin? I think what is a sort of a qualifier requirement. I think there's an expectation the applicant will provide some additional assessment, at least, to show that some additional assessment before they get across the line with that. That's what I read into it. But I think, yeah, any comment?
Yeah, well, it's not what I read into it.
Okay, you tell us.
Well, it seemed to me that the question was, in short, would the council be accepting of a low pressure system? And the answer, as I sort of heard it, was yes, but you'll need to demonstrate it at engineering acceptance stage rather than now before consent stage. And I guess we've also got the difficulty here that again, as I heard it, that email which gave the applicant some assurance came from, was it a Stacey Coy, who I think is manager for Three Waters, and I think that is a different person than was giving evidence to the panel today and expressed greater hesitation, if I put it that way, as to the use of a low pressure system. So yeah, look, it's a little bit murky, shall we say, and it may be that we can't resolve it right now, and that is something that the applicant can perhaps re-engage with the council on and see if we can provide the panel with some clarity as to what is the council's position. I guess as the operator of the relevant wastewater system, and also come back to the panel in terms of the RMA issues. What is the risk? What is the potential environmental effect if a low pressure system did need to be developed for lots 3 and 4 or units 3 and 4?
Yeah, that's right. So what the way we'll resolve this, we won't resolve it now, obviously. We'll ask that all of those written communications be forwarded to the panel. I'll issue on behalf of the panel a minute instructing what we expect from this point on, but it'll basically be the applicant to engage with council and advise us either separately or as part of the, or separately ideally, and then the right of reply can pick up on it later on. But depending on what comes out of that change, we may need to circulate that to the parties as well for any comment, but we'll see what comes from. So if that is acceptable, I won't label the point now, but we would like some clarity about this aspect. Okay. I have no other matters, Mr. Gardner Hopkins, that stand out other than, we look forward to receiving a written reply, considering all the evidence that's been heard and
yes,
set of conditions. So that's all I've got to ask, really.
So does that then get us to timetabling? Because
yes.
It would be good to have, I guess, some at least tentative, if not initial directions.
Yes.
And if something comes out, for example, in respect of the wastewater issue that requires more time, we can seek leave to do that. I'm keen to keep things moving.
Yes.
Conscious that it's now getting very close to the end of the year and a busy period for everybody. And I'm sure the applicant does want a decision, but of course it wants a decision made on the best available information. So
That's right. Yeah.
it's a balance, but yeah, look, I'm not sure how long it might take Mr. Greason to provide that consent order documentation with any explanation or update. I think I heard that Ms. Appleyard was happy to confer with him and provide a joint response or confirm she supports his response. So I don't know if that might, take a week. And then perhaps, simultaneously we can confer with the council's engineering team and see if we can get clarity or confirmation of what we thought was the position, perhaps within that same week. And then assuming that neither of those sort of raises, I guess, substantive more work to be done, then I'd like to think my reply could be done within a week.
Yeah. Well, you're doing a good job as a chair there, Mr.
Just suggestions only.
I had similar thoughts. Those two streams of work can happen at the same time. Absolutely, and that's where I was heading. I like to issue a minute almost the same day. If it's not today, it'll be tomorrow. That will settle this. And so there'll be two streams of work. And I was just going to ask Mr. Greason, you've basically done that work by supplying the initial appendix.
What we've drafted to Ms. Appleyard, if not this afternoon, probably tomorrow.
Right. So within a week, we expect some sort of joint response on where the appeal is at and what the scope of it is. That would be excellent. And then if Mr. White, if you can organise the written communications from the engineering team and send those all on to me with maybe your own understanding, which would help, I will then issue an instruction relating to that. Basically, it will be the applicant to confer with the right people and come to so we understand the council's position on it. Yeah, and any further work that might be required. And then Mr. Gardner-Hopkins will adapt that potentially into his right of reply to address the RMA aspects and whether he accepts that or not. That'll be part of the right of reply, I guess. And if more work is required, he might agree to do it. Who knows? But we'll see where we get to. All right. Anything else anyone wishes to say before I conclude the hearing? And otherwise, Commissioner Day and I will go up to the site again shortly, and then we will issue that minute tomorrow to get things underway. Thank you very much for your involvement. It's been an enjoyable hearing. It's full of its complexities, but we do appreciate the work that's gone in by all the parties, and we appreciate the gravity of the decision we must make. It's been well represented on both sides, if you like. So thank you all. And thanks to the administrative team for all your good work. Commissioner, conclude the hearing. Thank you.